Taking on a governor is a fairly daunting task. The governor has all of the resources available at their disposal, including an entire State Department of Justice.
And every lawyer is going to tell you he feels very confident about the arguments that he's going to make. But in this case, it was so clear the governor was violating the statute.
There hasn't been a long history of how to deal with public health emergencies because there hadn't been one since 1918. The consequence was that the executive branch dealt with it in the way that they thought they had the power to do.
In the onslaught of the COVID-19 pandemic, executive authority was put to the test. What can a governor do in times of emergency? Are there checks and balances in place to ensure that an executive doesn't go too far?
When Governor Evers initially declared the state of emergency in Executive Order number 72 in mid-March, there was a flurry of emergency orders that came out of that. It seemed almost on a daily basis there was another emergency order coming out either by the governor or by the Department of Health Services Secretary designee Palm at that time.
This is changing daily, rapidly, hourly, and our goal right now is to mitigate spread.
Legislature versus Palm was a lawsuit filed at the end of April 2020. The Wisconsin legislature was the plaintiff suing Andrea Palm, and the issue was whether the order that she issued, the Safer at Home order, whether she had the power to do that or whether she'd failed to comply with administrative procedures. And so the legislature challenged this directly at the Wisconsin Supreme Court.
Legislature versus Palm was decided on May 13, 2020, with the Supreme Court of Wisconsin ruling 4-3 against the Evers administration, thereby curbing their authority to issue lockdown orders, though not Governor Evers' ability to declare states of emergency.
That sort of gave lawyers in the state notice that the court is going to review these decisions, and the governor is not going to have unlimited power, unchecked power. He's going to have to make sure that he passes judicial muster.
The Milwaukee paper reports, quote, it will force the Democratic governor and Republican-controlled legislature to work together on the state's response to the ebbs and flows of the outbreak, a dynamic the two sides have rarely been able to achieve before.
The problem is then the legislature didn't go on to do anything else about the pandemic. All they wanted to do was stop the governor from doing what his health secretary and the experts in the area thought needed to be done to protect the public health.
We're doing the right things, and unfortunately, in this one fell swoop, 4 judges who didn't really care about what the statutes talk about have thrown our state into chaos.
So here's what happened after Legislature versus Palm was decided. The Safer at Home order is invalidated. There was no state of emergency in the state of Wisconsin, and things remained that way till the end of July.
As we approached the end of July, there seemed to be a concern about uptick in cases.
On May 27th, reported COVID deaths in Wisconsin peaked at 22. After that, the number dropped. Maybe the worst is over, some thought.
With cases rising, Governor Evers decided he would declare a state of emergency in Wisconsin. The problem was he had already done that once. Like every other governor in America, he had declared a state of emergency in the middle of March.
These emergency orders were coming out. They would all have statutes indicated on them that they've referred to for the authority. And I was starting to pay closer attention to those and actually do some homework and go look those up and see what they said. 323.10 is an emergency power statute that allows the governor to declare a state of emergency, whether it's a public health emergency with COVID-19 or a natural disaster or some type of warlike event. The governor gets all sorts of emergency powers. He can cancel private contracts, he can seize private property, but the statute comes with a limitation, which is that state of emergency only lasts for 60 days, and at the end of the 60 days, either the emergency ends
or the legislature has to approve an extension beyond 60 days.
In September, Governor Evers issued another executive order. It became apparent to me that the legislature was, for whatever reason, not going to act. Some speculated that it might be due to an upcoming election in November, and they didn't want to weigh in on it.
This was really a political decision by the legislature. They didn't want to have to take responsibility for dealing with the pandemic. They wanted other people to do it while they could stand up for what they thought their constituency wanted, which was freedom from having to deal with it.
If the legislature wasn't going to exercise their control over the governor, then I felt the citizens of Wisconsin have a right to do that, and so I stepped up to fill that void.
And so we put something together and we filed that original action October 15th of 2020. You can file a lawsuit directly with the Wisconsin Supreme Court, and this is allowed because our Constitution provides that the Wisconsin Supreme Court can exercise original jurisdiction over cases of significant importance throughout the state.
The problem with original jurisdiction is that the development of the case is stunted because it's only one argument to one court, one time. For example, in Legislature versus Palm, the Supreme Court took the case on April 21st, told everyone to file their briefs on April 28th. The decision was made on May 13th. If you ask any lawyer, and I don't care what the lawyer's politics are, what ideology they ascribe to, 7 days to put together a submission to a Supreme Court is an extraordinary burden, and you can't do your best work in 7 days.
If you go through a normal process of filing a lawsuit and then appealing and trying to get to the state Supreme Court, that can take 2 to 3 years. The people of Wisconsin were entitled to know in 2020, did the governor of Wisconsin have the power to keep the state in a state of emergency?
One of the biggest pushbacks that the Wisconsin Department of Justice, on behalf of Governor Evers, brought up in their biggest point was that I lacked standing to actually bring this action, that this was something that should reside between the governor, the executive area of state government, and the state legislature, and that I had no place in getting involved or getting in the middle of this.
We had to convince the Wisconsin Supreme Court that taxpayer standing doctrine was appropriate and that it was acceptable for citizens who are voters and taxpayers to challenge illegal government action.
In state court in Wisconsin, taxpayers can bring lawsuits if there is a pecuniary detriment to the taxpayer. State tax money is being spent illegally or improperly. Any taxpayer can have standing to challenge that legislation or challenge that action.
Governor Evers called up the National Guard as part of the pandemic response and as part of his emergency order declaration. After President Biden came into office, the federal government agreed to reimburse states that had called up the National Guard. One of the questions then was, well, does Mr. Fabick still have taxpayer standing? Ultimately, the Wisconsin Supreme Court found that he did.
In order to uphold standing for Mr. Fabick, the majority of the Supreme Court said, maybe the federal government in the future will stop paying for the National Guard, and therefore there would then be an injury to the taxpayers, and therefore this taxpayer has standing because in the future there might be an improper expenditure of state funds. That decision by the Supreme Court was met with extraordinary skepticism by many people, not just on the left, but the right as well, as to how the court could change the law on standing like that. The Supreme Court has opened the door up to basically allowing any citizen to sue about anything based on the Fabick case now, and that's not been the law in Wisconsin ever.
I was hopeful of a positive ruling by the court. I was also concerned that the court may be dragging their feet a bit and hoping that this would go away and it would get mooted out.
The argument we presented in Fabick versus Evers was a very narrow, straightforward statutory interpretation. We knew the governor had violated the statute, and it was clear as day. So the question is whether the statute at issue allows the governor to declare one state of emergency for a specific emergency, and that's it. If the legislature does not grant an extension of the state of emergency, the governor only gets to do it once. I mean, it's an extraordinary power. So it makes complete sense that if there's no agreement from another co-equal branch of government to extend the state of emergency, then it ends on its own.
That is the guardrail that we have that prevents our governor in Wisconsin from declaring perpetual states of emergency. And other states do not have that guardrail system. And some, in particular Illinois right now, has been under state of emergency since March of 2020.
I don't agree with the idea that the governor was overstepping. The statute says an order lasts for 60 days and can be dissolved by the legislature during that time. It was the court's interpretation that that 60-day limitation was binding for any given emergency. That is not in the statute per se.
So the argument from the Department of Justice, who was representing the Evers administration in this case, was that it was okay for Governor Evers to declare a new state of emergency in July and September because the school year started and cases were rising, and so this represented a new emergency. You can always say, well, the circumstances surrounding COVID are different now than they were 60 days ago. But if you apply that logic, you keep yourself in a perpetual state of emergency. You really have no end to the governor's ability to declare a state of emergency relating to COVID.
In February, the legislature finally got around to revoking his latest executive order. Within an hour of the joint resolution of the legislature revoking that, Governor Evers issued Executive Order 105. So he told the court that he wouldn't do that, and then he went ahead and did it anyway.
Assuming that there was serious flooding because of intense rainstorms, and the governor had to issue an emergency order about the flooding. Well, what if the flooding after 60 days increased? What if there are additional storms and more flooding? Of course the governor could issue another executive order to deal with that emergency. The idea that, well, just because an emergency started and didn't end within 60 days, the governor couldn't issue another executive order to deal with the emergency just seemed ridiculous to me. But the Supreme Court didn't think it was ridiculous.
On March 31st, the court did finally issue their ruling, and they agreed with the position of my case and invalidated all of the governor's executive orders that took place after the initial one in March of 2020.
In a 4-3 decision, the Wisconsin Supreme Court ruled in favor of Jeré Fabick, invalidating all of Governor Evers' additional states of emergency. All executive orders relying on authority from the declared state of emergency were thereby invalidated, such as the statewide mask mandate.
Justice Brian Hagedorn wrote this, quote, "The question in this case is not whether the governor acted wisely, it is whether he acted lawfully. We conclude he did not. State law says governors can issue health emergencies for up to 60 days, but after that, the legislature must approve any extensions."
The Supreme Court reached out to change the law in order to get to a decision that it wanted to reach. And that is called judicial activism. And of course, the majority that made that decision consider themselves to be textualists. And in the absence of an ambiguity, the statute says what it means. But in this instance, the court decided that it meant something more than what was written in the statute. Partially that's because the majority in the court currently is very suspicious of executive and administrative authority and power.
I would be resistant to any outlook that says, well, just cede all the power to the executive branch, whether it's the president or the governor, and let him control the situation, let him declare a state of emergency and suspend various laws. I can remember in the wake of 9/11, a lot of people thought that the federal government assumed too many powers and restrained civil liberties in a far too great way. So if you're saying that we can ignore the rule of law because of a public health emergency or because of a terrorist attack, then we really don't have the rule of law. There's a reason that we have separation of powers and a tripartite system of government, and you need it especially in the crises, not just the good times. The Constitution is there for the rainy days, not just the sunny days. What I think the lesson of all of this pandemic litigation should be is that people should remember the importance of their constitutional rights. People have fought and died so that our citizens can have these constitutional rights. And I was amazed at the willingness of so many people to voluntarily relinquish these rights in the spring of 2020 because of what some health official or bureaucrat stated that we should do.
The problem that a pandemic poses is that the exercise of personal freedom is the manner in which the virus or bacteria spreads to other people. There's a balance that has to be drawn between personal freedom and the freedom of the community to be free from a communicable disease. I'm not sure that we have the freedom to be completely selfish and to not look out for our neighbors, especially when it comes to something like a communicable disease. So that's a discussion that has to happen in America.
The situation has taught me that I need to stand up and be counted and put myself out there and try to right a perceived wrong that I have in a responsible, lawful way, and to do that through our court system. And I think a little bit closer scrutiny of these specific issues on what kind of power do the branches of government have in a crisis situation, and how far can they go, and what kind of constraints do we, the people, want to see instituted on that.
Although Jeré Fabick had his day in court and won his case against Governor Evers, the struggle to balance personal liberties with the public's health and safety continues throughout the country. How much power should the executive branch wield during times of crises? And what types of checks and balances should be in place? The debate continues at fedsoc.org.